floor over to BCAR President Scott Geller. Thanks, Scott.
Thanks, Pam. So, good morning. I'm Scott Geller, the current president of the Bucks County. Oh, there we go. Current president of the Bucks County Association of Realtors. We thank you for taking the time to join us this morning, and we are excited to have Carolyn Steinhofer, who is the Intake and Outreach Coordinator for the Housing Equality Center of Pennsylvania. Join us. Carolyn will be discussing two of the most challenging sections of the Fair Housing Act, accommodations for service and support animals, and the use of criminal records in tenant screening. And she will also take questions on possible issues that may arise regarding the impact of the COVID-19 pandemic on fair housing. As a reminder, questions can be asked through the Q&A function. Thank you and welcome.
Thank you. Good morning, everyone. So I'm going to share my screen so that you can see my PowerPoint presentation. I'll be going quickly through the screens, and I will take questions after each topic. So the first, we're going to talk about criminal records, then we'll talk about assistance animals, and we'll talk about possible fair housing issues with COVID. I'm going to go pretty quickly, and after each section, take questions. So in 2016, HUD released guidance on the application of using criminal records by providers of housing in real estate related transactions. So the reason that they did this is that actually a third of the US population has a criminal record. And across the United States, African Americans and Latinos are arrested, convicted, and incarcerated at rates that are disproportionate to their share of the general population. So consequently, criminal-based record barriers are likely to have a disproportionate impact on minority home seekers. For example, African Americans represent 12% of the total population of drug users, but they represent 38% of those arrested for drug offenses and 59% of those in state prison for drug offenses. When you look at the US population versus the US prison population, you can see the stark differences in how it's disproportionate. And your lifetime likelihood of imprisonment is outlined here. This is from the Sentencing Project using US Bureau of Justice statistics. So if for all men, your likelihood of being in prison is 1 in 9, but if you're a black male, it's 1 in 3. So over 95% of current inmates are going to be released at some point, and they're going to be looking for housing. So you have to understand that all criminal records are not the same. You know, someone who's been arrested is not the same as someone that's been convicted. There's felonies, misdemeanors, summary offenses. You have to consider the length of time since the crime was committed and the severity of the crime that was committed. So blanket bans, no matter when the conviction occurred, with no consideration of what the underlying conduct entailed or what that person has done since then, will not be able to meet the burden of showing a substantial, legitimate, non-discriminatory interest. So though blanket bans saying that, you know, we will not accept anyone with a criminal record, no matter when the conviction occurred, or we will not accept anyone with a criminal record, even if it's just an arrest, that's what will get you into trouble. So you want to make your decisions on a case-by-case basis. Consider the nature and the severity of the conviction and the amount of time that's passed since that criminal conduct occurred. So research has shown that over time, the likelihood that a person with a criminal record will engage in additional conduct decreases until about 6 or 7 years, until it approximates the likelihood that a person with no criminal record will commit an offense. So that 6 to 7 years study kind of has shaped a look back period, and we'll talk about that more later when developing your own criminal record policies. So you want to also consider a less discriminatory alternative. So you want to look at, you know, evidence that the individuals maintained a good tenant history before or after the conviction or conduct, you know, evidence of rehab efforts, facts and circumstances surrounding the conduct, and the age that they were. You know, someone who committed a crime when they were 20 years old and they're now, you know, 35, they're probably a very different person. Exclusions because of prior arrest. You can't prove that the Supreme Court has shown that the mere fact that someone's been arrested shows little, if any, proof that they've actually committed that crime. Just shows that someone reasonably suspected and they were apprehended of that offense. So we can't use arrests to prevent someone from accessing housing. You won't be able to show that an arrest, someone's been arrested, is a valid reason that would threaten the safety and residence of and property of other residents. So there is an exemption from Fair Housing Act liability, and that's if a person if they've been convicted of the illegal manufacture or distribution of a controlled substance, then housing providers will not be liable under the Act for excluding individuals because they have been convicted of the illegal manufacture or controlled substance. But note that that's only conviction for drug manufacturing and distribution only. It does not include arrests for such offenses, and it does not include conviction for possession. Also, consider disability-related criminal behavior. The Fair Housing Amendments Act defines disability as a physical or mental impairment that substantially limits one or more major life activity. It also includes those with a history of an impairment and those perceived as having an impairment, those recovering from addiction. Current users of illegal drugs are not covered. And then the Fair Housing Amendments Act requires housing providers to make reasonable accommodations for people with disabilities, changes in rules, policies, or procedures. So if an individual has a criminal record due to conduct that resulted directly from a mental health disability or addiction, and if they can demonstrate that they've received treatment or medication that's eliminated that behavior that led to the criminal conduct, then that person could request a reasonable accommodation to make an exception to the housing provider's ordinary criteria regarding criminal background. And that's something that should be considered. Now, the Fair Housing Act doesn't require that housing providers rent to anyone who constitutes a direct threat to the health and safety of others, or someone who would risk substantial damage to the property, like someone with recent convictions for arson, for example, would be a direct threat to the health and safety of others. However, you can't deny housing to people with disabilities based on fear, speculation, or stereotypes about particular disabilities. So that denying someone housing or evicting them because of a direct threat has to be based on reliable evidence and objective evidence. So you need to take into account the nature of the risk of injury as well as the probability that injury will occur. And are there any reasonable accommodations that would eliminate that direct threat? I give the example of someone who may have a mental health disability and stop taking their medication and threatened a neighbor with a baseball bat. And now they're being given an eviction, and they can come back and ask for a reasonable accommodation and say, well, this was directly due to my mental health disability. I'm now taking new medication, I'm getting supervision, I'm getting increased therapy and monitoring, I have a social worker involved, etc. So can you please make a reasonable accommodation and give me a second chance to continue my housing. So that would be, reasonable accommodation for them, allowing them an opportunity to show that they've taken steps to mitigate the behavior and that's unlikely to reoccur. So the HUD guidance, just in summary, criminal-based history restrictions to housing disproportionately affect African Americans and Latinos. So you can appropriately consider criminal history information when making housing decisions. No one's saying that you have to rent to people who would be dangerous or be a direct threat. However, arbitrary and overly broad criminal history related bans will lack a legally sufficient justification, and as well as anyone, denying housing to anyone just because they have a prior arrest can't be justified and will violate the Fair Housing Act. So the criminal history selection criteria for residents you have to show a substantial, legitimate, non-discriminatory interest. You have to take into consideration the type of crime, the length of time since the conviction, the nature, severity, and recency of the crime. You'll still have to show that you're making these determinations on a case-by-case basis, and be careful that your criminal history policies are not being selectively applied, that they are applied consistently with everyone without regard to race, national origin, or other protected classes. So there's two cases that you've probably heard a lot about. The one is the Fortune Society versus Sandcastle Towers. So that was filed in the U.S. District Court in the Eastern District of New York. So Fortune Society was a nonprofit serving formerly incarcerated people. And when Sandcastle Towers learned what type of work they did, they said, well, we don't want to rent to any of your clients because we don't want anyone with criminal records living in Sandcastle Towers. So that case was resolved, and I believe about 6 months ago, with a huge settlement. And it was a landmark federal civil rights case that established that lawsuits can be brought against private landlords who impose blanket bans on renting apartments to people with criminal records. Another case, which you may or may not have heard about, is the lawsuit against Sterling Glen Apartments, which was a 300-unit apartment complex in Chesterfield, Virginia. So the lawsuit argued that their criminal background policy was overly restricted, that it disproportionately impacted communities of color, and the lawsuit sought to change the criminal record policy of Sterling Glen. So their Sterling Glen's policy, they were denying housing to anyone with any type of felony and anyone with a record where adjudication was withheld or deferred. Additionally, anyone with an active status on probation or parole was also denied housing. So the result of the Sterling Glen Apartments lawsuit is the development of a model criminal records policy, which I can share with you after the presentation. It can be emailed to you. But basically, we'll go over it in quickly. So you want to qualify prospective tenants on factors other than their criminal background first. Do they qualify income-wise and credit-wise first, right? If they do, provide a tentative acceptance contingent on a criminal background check. After you do the background check and determine whether there's a criminal background that's of issue, we'll talk about what's a covered criminal background. If there's not, then accept and house them. If there is an issue with the criminal background, offer the applicant an opportunity in writing for an individualized assessment. So give them 14 days to provide the information. They can include, they can tell their story. They can say, well, you know, I have recommendations from my probation officer, my case manager, other landlords, etc. This is what happened. I was 21 years old. I was addicted to drugs. I'm now 27 years old. I've completed a recovery program. I'm married. I have 2 kids. I'm employed full-time. They can lay out their case, and that can be done in writing or verbally, that they can give you an explanation. You want to provide the final decision in writing and retain all records. Record retainment is really important in defending yourself against a fair housing complaint. So covered crimes in this model criminal record policy include felony criminal convictions within the past 5 years related to property offenses, major drug offenses, fraud offenses like writing bad checks or fake IDs, major violent offenses against people, and sex offenses. But it did not cover arrest charges. If a conviction was expunged or reversed, then you would not, that would not be a problem. And additionally, applicants will not be treated differently whether they're on probation or parole. So the individualized assessment, that if someone has committed a covered offense, right, within 5 years in one of those categories, so you give them an opportunity to give you some information. You can, they can give them a 2-week time period. You can ask for evidence of rehabilitation efforts, their age at the time of conduct, the facts surrounding the circumstances. Have they maintained good tenant or employment history before or after? Was the conduct or conviction, was it due to a disability, including mental illness? And is there any heightened risk of crime for your property or other residents? And also, is there an error in the criminal record? A lot of times there is. So you need to give people a chance to explain that and prove that as well. So don't rely on just an arrest to make an adverse decision. And this applies to applicants and current tenants. If a current tenant if you're going to take action against them, make that decision based on their conduct, not just on the mere fact that they were arrested. We recommend that you don't ask about arrests if someone's ever been arrested on the application. It's not illegal to ask that, but someone may want, going down the line, may want to know why you're asking that and what's your answer going to be, because you can't deny them if they just have only ever been arrested. So don't use a blanket ban based on any type of conviction. It sweeps too broadly. It will likely disqualify qualified applicants and possibly draw a civil rights complaint. And don't use an unreasonably long look-back period, not a 20-year look-back period or a 100-year look-back period. You don't want to have the same look-back period for felonies and misdemeanors. You need to vary that, and you need to consider that, the conduct varies on the severity of the crime and the nature of the conduct. So there we go. Having trouble advancing to the next slide. So don't evict a successful tenant because you discover a conviction on the record after admission, after years of good tenancy. That may get you in trouble. Don't forget to think about reasonable accommodations. If your applicant or tenant has a disability, don't forget to offer that individualized assessment. Have a clear policy, apply it consistently, distinguish between the different types of conviction and how that conduct is related to being a good tenant. Train your staff on how to apply the policy. And audits do show high levels of unequal treatment based on race to applicants with similar criminal histories. We've seen that as well. We've seen where Black applicants with criminal backgrounds are being treated worse than white applicants with the same or similar criminal background. So you want to be very, very careful that that does not happen. And have that clear policy and practice that allows every applicant that you come across that has a criminal background the opportunity to make their case before being rejected. And they recommend that this individualized assessment that's done should be performed by one person in your office so that the outcomes are consistent. But it should also be done by someone who is not the original decision maker. So you would have someone who's the original decision maker, and then a second person do the individualized assessment that would handle all the individualized assessments for your applicants. You can visit our website at equalhousing.org. Please sign up for our Fair Housing News. You can learn a lot. You can request training for you and your staff. Your colleagues, you can hear about upcoming trainings that we have. And if you have any questions, I want you to have my contact information so that you can contact me directly. You can contact me confidentially at any time. So I am going to go take questions now on criminal backgrounds. So
Okay.
I'll try to do my best to answer. It's hard sometimes because sometimes they're so complex or convoluted and everything has to be considered on a case-by-case basis, but I'll do my best to answer any questions you might have.
We do have a question, Carolyn. Uh, the question is, do you have to wait 14 days for them to explain if you have other viable prospective tenants that qualify?
I would say that you do not.
Okay. Okay, that was the only question.
Yeah. Okay. All right. Let's go on
Thanks.
to assistance animals. All right. Okay. So we're going to discuss how assistance animals under state and federal fair housing law differ from Americans with Disability Act service dogs. We'll talk about HUD guidance, how to evaluate requests and verifications. We'll talk about insurance policy restrictions and the new law that was passed in Pennsylvania about a year ago. So just as a refresher, the Federal Fair Housing Act covers these 7 protected classes. Disability is one of them. The Pennsylvania Human Relations Act adds 2 additional protected classes, age over 40, and users, handlers, and trainers of assistance animals for people with disabilities is covered under the Pennsylvania State Human Relations Act. And what I think is really interesting is that it doesn't necessarily in Pennsylvania, it's the users, handlers, and trainers of assistance animals for people with disabilities doesn't necessarily require that the individual have a disability. So I think that's really different than what the federal law states. There's some exemptions. So if it's an owner-occupied building with 4 or fewer rental units federally, but in Pennsylvania, it's 2 or fewer units under Pennsylvania state law. The for sale by owner exemption under federal state law, note that Pennsylvania Human Relations Act does not state that exemption. And there's never an exemption for discriminatory statements or advertising. So that you understand the difference between service dogs and assistance animals under the Americans with and assistance animals under the Fair Housing Act, I want to talk to you for a second about the Americans with Disabilities Act. So the ADA prohibits discrimination in places of public accommodation. So we're talking about restaurants, libraries, post offices, and those animals that are authorized to go in those places are 99% of the time service dogs. And they are individually trained to do work or perform tasks for people with disabilities. So it's a very, very specific definition. And those animals are almost always dogs, and they are individually trained to work or perform tasks. However, let's compare that to fair housing law. So someone in their own home has a lot more rights than someone in a place of public accommodation. And under fair housing law, we call them assistance animals because they can be any type of animal. It could be a service dog, an emotional support dog, an emotional support cat. It could be a therapy animal. So they do not need to be trained and certified. The assistance animals for fair housing purposes just have to allow a person with a disability equal opportunity to use and enjoy a dwelling. So it can include different types of animals. It can be any type of animal within reason. It has to be a typical household pet. So there's no assistance giraffes or alligators. That's not reasonable. It does not need to be trained. And there is no official certification for assistance animals or for emotional support animals. People who go online and pay money to get an emotional support animal registration are just getting scammed out of a bunch of money. And we'll talk about what is a valid verification in a couple minutes. So just quickly, disability is defined very, very broadly by the Fair Housing Act. It's a physical or mental impairment that substantially limits one or more major life activity: walking, talking, seeing, hearing, breathing, working. We just went over this a couple minutes ago, so I'll go quickly. So reasonable accommodation is a change in rules, policies, and services. So you allowing an assistance animal, even if there's a no pets policy, those pet fees and pet deposits for assistance animals must be waived. And you must make an exception. If you have a pet policy that has a weight limit, you would need to make an exception to that weight limit for an assistance dog. So what's reasonable? So what's reasonable differs for everybody. But the law has spelled out that a request for an accommodation is reasonable if it doesn't cause an undue financial or administrative burden to the housing provider, if it doesn't cause a basic change in the nature of the housing program available, if it won't cause harm or damage to others, and if it's technologically possible. So how should the request be made? So it's the responsibility of the person with the disability to make the request. It is not the responsibility of the housing provider to offer or suggest an accommodation, even if they're aware of the disability or disability-related need. These requests can be made verbally. We recommend that they're made in writing, but they don't have to be. And the request can be made by someone on behalf of a person with a disability. But there must be a connection between the disability and the need for the accommodation. They can ask for that accommodation at any time, when they're applying for housing, when they're moving in or moving out, or even during an eviction hearing in front of the court. So I've seen in the past couple years, a lot of housing providers using standardized forms for accommodation requests. I want to go over this with you. So having a standardized form is okay, but there's a couple things that you should be aware of. First of all, you can't require that a person use a certain form to request a reasonable accommodation. So you can say, here's a form I'd like you to fill out, but you cannot require that they fill out that form, because you can't require that the reasonable accommodation request be made in a specific manner or at a specific time. And you have to consider the request even if the person didn't use your preferred form or your preferred procedure for making the request. And you can't deny a request just because they didn't use that form. Additionally, we're seeing some forms that contain invasive questions or are burdensome and are designed to be discouraging. So you want to make sure that your form, if you're asking people to fill it out, doesn't contain invasive questions and isn't overly burdensome. So you can't ask questions that require someone to waive their rights to confidentiality regarding their history, their medical records. You can't ask about the nature and severity of a disability or a specific diagnosis. You cannot ask if a person is able to live independently. So when can you ask for verification to make sure a disability and the need for the accommodation is legit? So if a disability is obvious and the need for the accommodation is clear, such as a person who has a visual impairment and they have a seeing eye dog, then you can't ask for additional documentation. You must accept that on face value. If the disability is known but the need for accommodation is not clear, you can ask for information to evaluate the disability-related need, such as someone's in a wheelchair, so you see that disability, but they're telling you that they have an assistance cat. You're saying, what? Then you can ask for information to evaluate that disability-related need. It may be that they have another disability and they need emotional support. Right? If the disability and need are not known, such as, might be in a seizure disorder, PTSD, mental and emotional health disabilities, then you can request documentation both that the tenant has a disability and a disability-related need. So, and those verifications should come from medical health professionals. As I mentioned before, the emotional support dog certifications that people print out online are not going to meet the muster of verification. So you also want to consider if what they're asking for is unreasonable, is there another solution? Engage in an interactive dialogue. Do not automatically just say no. Say you don't want to stall or delay in responding to a request. If you don't know the answer, if you're not sure if the request they're asking is reasonable, say, listen, I received your request. I'm evaluating it. I'll get back to you as soon as possible. Don't just make the mistake of not responding. And engage in an interactive dialogue with that individual so that they know that you're working on it and you try to understand their needs and as well as understand their needs as well as your needs. So the verification should come from a medical or other professional that's familiar with the patient making the request, familiar with their disability, and familiar with the disability-related need for the animal. Okay, and again, no official certification or registration for emotional support animals or assistance animals currently exists. So when you get a request, you want to look at a couple things. We call it the dance. First of all, does the person have a disability as defined by the Fair Housing Act? Or are they requesting a change in your rule or policy? They're requesting an accommodation. Is this necessary for their full use and enjoyment? Does it impose an undue financial or administrative cost on the housing provider? And would it fundamentally affect a change in the landlord's business? So if the answer to the first three questions is yes, and the answer to the last two questions is no, then the housing provider should grant that request. So there's other considerations, like the pet owner has to clean up after the animal and provide all proper care. They have to maintain control of the animal. It has to be leashed outside. They're responsible for any damages caused by assistance animals. Dogs have to be properly licensed, and they have to be vaccinated as required by law. And if those animals disturb neighbors, then that accommodation may no longer be reasonable. So what if your insurance policy would terminate or increase in cost, or the policy terms would be adversely affected because of a certain breed of dog, like pit bulls or Akitas or German Shepherds? Well, you have to remember that an accommodation is unreasonable if it imposes an undue financial or administrative burden on the housing provider, right? So you may need to show that comparable insurance without that breed restriction is unavailable. And if an insurance provider has a policy of refusing to insure any housing that has animals without an exception for assistance animals, then that insurance policy provider may be held liable for discriminating against individuals with disabilities. So you may want to shop around if your insurance provider is very restrictive. Pennsylvania passed the Assistance and Service Animal Integrity Act in 2018. So this protects landlords and condo and homeowner associations from being held liable for injuries caused by a person's assistance animal or service animal that the landlord has permitted on the property as a reasonable accommodation. So it provides indemnification. It also makes it a third-degree misdemeanor to misrepresent an animal as an assistance or service animal, to intentionally create a document misrepresenting an animal as an assistance animal, or to provide a document falsely stating that an animal is an assistance animal or service animal in housing. It's also a third-degree misdemeanor to fit an animal with a vest or sign, which indicates the animal is an assistance animal if it's truly not. So the third-degree misdemeanor is a summary offense, and it can also have up to $1,000 fine. And it's okay it is okay to notify your tenants of this law. That's not being discouraging. You're just saying we're just making you aware of this law, right? So some common mistakes that we see: always requiring forms or always requiring that they fill out your preferred form, being rigid with rules, policies, and procedures, not responding timely to a request has been deemed by the courts to be an actual denial of the request. So don't stall or delay in responding to requests. Engage in an interactive process. Make sure all employees that deal with tenants and prospective tenants are trained. And just being sensitive can go a long, long, long way to avoiding a fair housing complaint. Some additional common mistakes are, refusing to allow someone with a disability the right to an assistance animal when it's reasonable, or evicting someone because they requested an assistance animal, telling someone, sure, you can have the assistance animal, but you have to pay these pet fees and pet deposits. Those do not apply to assistance animals. And also requiring training or certification, and do not inquire about the nature or severity of a person's disability. So the HUD and the Department of Justice released a joint statement on reasonable accommodations under the Fair Housing Act. Here is a hyperlink. You will get a copy of this slide deck in a PDF form after the webinar. And so you'll be able to click on this hyperlink to access this document. If you assess reasonable accommodation requests in your line of work, you should have this document available on your laptop so that you can search quickly. You should probably also print it out so you can peruse it at any time. I have it printed out in my file and refer to it frequently. Here's a link to the HUD guidance that was released in January if you want additional information, although we went over the gist of it. If you want a copy of that guidance, here's that document. We have produced a guide to reasonable accommodations and modifications that we're providing free. And it is very, very helpful. It's designed to assist people with disabilities as well as housing providers. So you can download the copy, or I can mail copies out to you. If you're aware of discrimination, we ask you to report it to us. There are statutes of limitations. Complaints can be filed with HUD for up to a year. Pennsylvania Human Relations Commission 6 months, and individuals can file lawsuits in federal court for up to 2 years from the date of the incident. So with that, I will take questions on assistance animals.
Hi, Carolyn. There are no questions posted
Oh,
right
great.
now. So you
Okay.
can move right along.
All right, great. So we'll talk about COVID. So this is so new and uncharted territory. So I don't know how this is going to go. We don't know how this is going to play out, but the National Fair Housing Alliance released a COVID-19 update, which I'm going to share with you, which kind of their update is they're kind of laying out the argument that COVID-19 may be considered a disability under the Fair Housing Act. So just as a reminder, the Fair Housing Act prohibits housing providers from asking whether someone has a disability. You can't ask people to disclose medical conditions, including medical conditions that might make them at increased risk of COVID infection. Asking about exposure to the virus or test results will generally violate the Fair Housing Act. We've seen already some discriminatory treatment based on COVID-19. We've seen housing providers refusing housing to healthcare workers because they fear that the worker may have been exposed to or contracted the virus. And we've seen individuals who are trying to transfer from nursing homes into independent living or private housing being denied because there's this assumption that they may have been exposed to COVID-19. And then we've all seen reports of people treating people from China differently or people from Asian countries differently because of the perception that they may have COVID-19. These all violate the state and federal fair housing laws. So you can encourage your tenants, or if a condo association or homeowners association can encourage individuals to adopt infection control practices such as regular hand washing, wearing masks and physical distancing, and applying those policies and practices recommended by the CDC to prevent spread of the virus are justified, and they are designed to assume that everybody has the virus. So here's the caveat, right? So the Fair Housing Act provides that housing does not need to be made to people whose tenancy would constitute a direct threat to the health or safety of other individuals. The fact that COVID-19 is a highly contagious disease raises the question as to whether this direct threat exception will apply to COVID-19, and we simply do not know, okay? So we do know that under the Fair Housing Amendments Act that the application of the direct threat exception has to be based on an individualized evaluation of the individual and informed by reasonable medical judgments of the CDC or state and local health authorities. And if a direct threat can be reduced or eliminated by making a reasonable accommodation, an accommodation should be offered. So there's it's really uncharted territory. At a time that, this NAFA update is saying that at a time when the public is advising people to stay home, that evicting someone with COVID-19 is antithetical to the recommendations of public officials. So for a person with symptoms who's regarded as a potential direct threat, offering self-quarantine procedures may be regarded as an appropriate reasonable accommodation that must be considered to alleviate that direct threat. Alternatively, someone who has a record of having a communicable disease, but who has recovered, may be protected because their tenancy no longer poses a threat of infection. And a conclusion about whether the tenancy of an individual constitutes a direct threat to the health and safety of others may not be based on stereotypes or assumptions. It has to be based on objective factual evidence. So here's the hyperlink to the National Fair Housing Alliance's COVID-19, and it's a 4-page document. Also, courts are closed in Pennsylvania through July 10th. So there's no eviction filings, no eviction hearings, and no lockouts in Pennsylvania until at least someone can't even go file in court until July 11th. So all evictions are illegal at this time. If you want to look for county-specific information on court closures, here's the link to that. And then the CARES Act provides additional protection for tenants in federally assisted housing. So evictions are halted until July 25th. Here's the link to find out more about that if you wish more information. The Housing Alliance of Pennsylvania created a Landlord Toolkit for responding to COVID-19 impacted tenants. I wanted to share that with you, so here's the hyperlink for downloading that Landlord Toolkit. Again, we have our reasonable accommodation and modification guide that's available for you. Sign up for our newsletter, visit our website, and here is my contact information. And if there's any questions, I'd be happy to answer those questions.
Hi, Carolyn. No, there are no questions posted right now. We did have someone request the links to be put into the chat function. We're not able to do that right now, but I just want to remind everyone that you're going to be getting copies of everything by email. So hang in there, you'll get it.
Yeah.
I just really want to thank you, Carolyn, for your time. The Housing Equality Center has been a partner of BCARS for many years, and we greatly value your input, especially during this time of uncertainty for our members and obviously the rest of the world. So thank you so very much. And I will say, if anyone has questions that come to you after the fact, you can reach out to Carolyn. I'm sure she wouldn't mind. Or you can email staff at the BCAR office, and we'd be happy to get anything answered for you. But with that, I think we're going to end our session. We hope
thank you. Yeah.
Thank you so
feel
much.
I just want to say, feel free to reach out to me anytime. You can even call me anonymously, and I'll walk you through the steps. I don't want to see anyone get in trouble. I'd love to help you, and I have landlords, property managers, and realtors call me frequently, and we'll walk through things. And if I don't know the answer, I'll find out the answer for you. So.
That's right. Well, thank you so much.
You're welcome.
Thank everyone who was on this webinar. We really appreciate your time, and I'm certain that you got a lot of very valuable information from this. So with that, I think we're gonna end this webinar and ask everyone to stay tuned, because we'll have future episodes coming up. So thank you all. Goodbye. Stay well, everyone. Thanks, Carolyn.
Thank you. Take care.